Okay. Hello, everyone. My name is James Law. I'm an associate attorney at Reinhardt Berner Van Duren, and I've been practicing for approximately 3 years now. And throughout my practice, I've had an opportunity to become acquainted with Proposition 65. It's my pleasure to try to share some of the knowledge that I've learned throughout my research and dealing with Proposition 65 issues for some of our clients. So just to get started with a little bit of housekeeping, if you have any questions throughout the presentation, please just use the question box and type in the questions, and my assistant here, Nancy, will share any questions that she has that's presented by the attendees here, and I'll do my best to answer any questions you might have throughout the presentation. Okay. So just to get started with Proposition 65 and dive right in. So Proposition 65 it stands for the California Safe Drinking Water and Toxic Enforcement Act of 1986. So it's been on the books for about 30 years now, and it's commonly referred to as Proposition 65 because it was passed by a direct voter ballot initiative, and the proposition on the ballot was 65. So the shorthand and the popular name is Proposition 65. And the overall goal of the law is that it institutes a warning regime. The goal of Proposition 65 is to inform consumers of the risk of cancer and reproductive harm due to certain kind of chemicals in the environment that's introduced by way of product exposures or food exposures, environmental exposures. And when the law was first implemented in 1987, the list of chemicals there were approximately 26 chemicals identified for cancer, and there were 6 chemicals identified for reproductive harm. But the overall structure of Proposition 65 and the goal is that it's all about warning consumers prior to their purchase of a food, prior to their exposure to a chemical through a product or a chemical introduced through an environment. So Proposition 65, this is the core provision of what Proposition 65 prohibits. It says that no person in the course of doing business shall knowingly and intentionally expose any individual to a chemical known to the state to cause cancer or reproductive toxicity without first giving clear and reasonable warning to such individual. So there's a few different key provisions in this. One of them is knowingly and intentionally. Intentionally has never been defined. There's currently no case law out there that says anything about what intentionally means. There's no case law or regulation that says exactly what intentionally means under the statute. However, knowingly is defined in the statute. Knowingly refers to knowledge of the fact of exposure. So it's really geared towards asking the question whether the business entity or person who introduced the chemical to a consumer of a product knew that the chemical was in the product and that there would be an exposure, that somebody, and that's all it really refers to. And then the other parts of this is the clear and reasonable warning. That's one of the core provisions of the law. So for a warning to be clear, it has to be sufficiently clear to communicate the warning that this product contains a chemical known to the state of California to pose a risk of causing cancer or reproductive harm. So the warning has to be sufficiently clear. And however that warning is made is really up to the person who is introducing the chemical through a product or a food or the environment of what exactly that warning is going to be. And the warning also has to be reasonable. Reasonable in the sense that how the warning is communicated to the consumer. And that can be done in a host of different ways. That can be done through signage. It can be done through advertising. It can be done through labeling on the product. It can be done through shelf labeling in the store. So there's a myriad of different ways that a warning can be made to the consumer. But the core point is that the method that's employed must be reasonable to inform the consumer this, the warning that a chemical that's been identified to pose a risk, a cancer risk or a reproductive risk, will cause cancer or reproductive harm. And that has to be done prior to the consumer making that, that purchase. So one of the questions that might come up is that, so you're an out-of-state manufacturer or distributor, and you may wonder, why should I really be worried about Proposition 65? Well, Proposition 65 has been on the books for 30 years, and it has ensnared a lot of different kind of distributors and manufacturers from out of state, where a product ends up in California, being sold in California. A consumer group tests the product, finds out that there's a chemical that's listed by the state of California, and that the chemical, there is no warning. So they initiate a suit. And because a lot of the burdens in proving that the product did not require a warning is very expensive, usually what will happen is there'll be a settlement of the suit before it gets very far. So because of that, because it's so easy for plaintiffs to file a Proposition 65 lawsuit, there's been a cottage industry that has grown up around the law. And one example of a consumer group is As You Sow. Another, and I've listed the link here so you can get a little bit better sense of what they are. But last year alone, they got $500,000 in settlements, and they were not the most active consumer group out there. Another consumer group that had been active in the previous year, Center for Environmental Health. They filed 99 different Proposition 65 lawsuits, and they were able to get $4.6 million in settlements in 2015 alone. So we've got a lot of different consumer groups out there that are very, very familiar with Proposition 65. They are looking for products that contain a chemical that's been identified by authorities in California as posing a cancer risk or a reproductive harm risk, and filing a lawsuit. And the defendant is in a position where now they have to decide, is it worth the money to defend, or is it better to try to settle? And usually the goal in most of these Proposition 65 suits is to settle for as little as possible to get out before deciding to move forward with litigation, which can be expensive. The average settlement cost that's been identified by insurance groups that I've seen, it averages about to $100,000 for the total cost of the settlement. That would include the civil penalty and the attorney's fees penalty. The Office of the Attorney General publishes every single year a list of all the different settlements that have been instituted in the, by year. List the consumer group, list the defendant in the lawsuit, list the civil penalty that was identified, and list the attorney's fees that were garnered. And when I looked at 2015, there's a very, very wide range of settlements. Some settlements are as low as $17,000. Some settlements are in the hundreds of thousands of dollars. So really it will depend, but it'll depend on a number of different factors: how many products were sold, what the profits were, the intentionality or the level of culpability of the defendant in introducing the chemical without a warning. So the range will vary quite significantly. But one of the things that's a benefit is that all of this stuff is public, so you can learn very, very quickly what the average settlement amount is to get a better handle on what a reasonable settlement amount might be. So what we look overall over the past 30 years that Proposition 65 has been in place, there's been over 16,000 Proposition 65 lawsuits filed. In 2015 alone, there were 583 Proposition 65 claims filed. The total settlements were greater than $26 million. Civil penalties were approximately a little over $5 million. whereas the attorney's fees were closer to $18 million, which is quite significant. So you can see why there's a lot of activity with Proposition 65 and how this has encouraged a cottage industry of plaintiffs' lawyers that will specialize in Proposition 65. But they're very, very easy lawsuits to make. There just has to be a good faith basis that a warning should have been on a product and that there was a chemical, and it's on the defendant to essentially defend. So that usually will encourage settlements very, very quickly. So because of that, it's a lower risk for the plaintiff, higher risk for the defendant, and they have a lot of incentive to bring the Proposition 65 case. I read somewhere that current Governor Jerry Brown in California, he had likened Proposition 65 to a frivolous shakedown because of the fact that it was so easy for plaintiff lawyers to bring a Proposition 65 claim and to obtain a settlement rather quickly. So the question about what chemicals require warnings. I said a little bit earlier that in 1987, the list for cancer was about 26 different chemicals that were identified, and approximately 6 for reproductive harm risk. And now there's over 900 listed chemicals, so it's grown quite a lot over the last 30 years. The list is updated once a year, and it's there's a number of different ways that a chemical might be added to the list, but primarily it's driven by scientists and health professionals and experts that identify through the latest kind of scientific studies what kind of chemicals that are out there, whether naturally occurring or synthetic chemicals that may pose some kind of a risk of cancer or reproductive harm. And throughout that process, there are also less often chemicals that are on the list that might become delisted. So it's really, really important to keep abreast of the list every year to see if there's any new chemicals that are added, or if there's chemicals that were previously identified as requiring a warning that are delisted, so you don't have to require a warning for that chemical anymore. Any new chemical that's added to the list, there's a 12-month grace period to either reformulate your product to remove the chemicals from the product, so that way you don't have to worry about a warning because the chemical in question is no longer used, or the alternative to supply a warning, a Proposition 65 warning, whether through labeling or signage, advertising, whatever method that you choose. But that has to be done within 12 months after the chemical is listed. There's a question?
Yeah, we have a question from the audience.
Mm-hmm.
He says, I just wanted to confirm that the following statement is indeed true. It was something I saw on one of the websites I visited. And the statement is, under the OEHHA decision, products that contain any trace of BPA must be pulled from the shelves or come with a warning by May 11th, 2016.
Okay, I have not seen that recent statement on the OEHHA about BPA. I know that is a listed chemical. I'm not familiar exactly when that was listed. But if the chemical is on the list that's been identified by the OEHHA, and that stands for the Office of Environmental Hazard Assessment, or Health Hazard Assessment, sorry. They're the ones that are in charge of putting this list together. So if they've listed a chemical like BPA, and there's no safe harbor, which I'll explain in a little bit, identified for BPA, then if your product contains BPA, a Proposition 65 warning is required. The only other alternative is to either not sell the product in California, or if you're going to sell the product in California, to supply a Proposition 65 warning if you can't reformulate the product to not include BPA. So it'll really kind of depend. I would have to look more closely into BPA to get a firm answer on that. But those are some of the general kind of principles that you have to look at. Is a chemical on the list? When was it added to the list? and what can I do? Can I reformulate the product so that way it does not contain a chemical that's on the list that would require a Proposition 65 warning, or can I simply say I'm willing to accept that I have to supply a warning, put the warning either through a label or any other method that's identified as being acceptable, and so that way you can protect yourself from a liability. Because remember that Proposition 65 is a warning statute. It's a warning regime. So even though your product contains BPA, that doesn't prevent you from selling the product in California. What's required is that you supply a warning when you sell the product in California. And my contact information is also at the beginning of the slide. So if there's any follow through of this presentation, a specific question that you might have, please feel free to email or contact me. So safe harbor levels, this is what I was referring to before. So there's a number of different chemicals, even though there's 900 on the list. Some chemicals have been identified to include a safe harbor level. For cancer, the scientific term for it is a no significant risk level, also stands for NSRL. And what this is a safe harbor level for cancer that's calculated. It's an amount that's calculated to result in one excess case of cancer in exposed population of 100,000, assuming a lifetime exposure at that level in question. So this is something that's scientifically validated, and there will be, for example, lead contains a safe harbor level for. So if the product has a concentration or would only result in exposure below the safe harbor level, then that would not require a warning. Whereas if it's over the safe harbor level, then that would require a warning. For reproductive harm, it's based on the maximum allowable dose level. And what that is the level at which the chemical would have no observable adverse reproductive effects, assuming exposure at 1,000 times that level. So again, this is something that's scientifically validated, and there's a number of chemicals that do have a safe harbor level. So that's another thing that you might have to look at for, well, what is the chemical in question? Is there a safe harbor level that if the chemical is in the product, but it's below that level, then a warning might not be required, even though that chemical is present in the product, but it's a very, very small amount. And it's based on levels of exposure and not concentration. So for the safe harbor levels, the OEHHA, they've established 300 different safe harbor levels. And there's a link that's provided here that you can go to. And if there's a chemical that you know that is present in your product, you can simply look through the list and see if the chemical is on the list and what the safe harbor level is. If there's no safe harbor level, then that means that if the chemical is present in the product, it must include a warning, or you either have to reformulate to remove that chemical in order to avoid the necessity of providing a warning. So, I mean, in a shorthand, you only get the benefit of a safe harbor level if there is a safe harbor level that's been identified. So, just as an example, if you look at lead is on the list of the 900 chemicals that have been identified, but there's also a safe harbor level for it. So the NSRL that relates to cancer, they've identified that 15 micrograms per day of exposure orally, that would be the safe harbor level. So anything 15 micrograms or under is considered a safe harbor that is not going to pose any kind of risk of causing cancer. The MADL that relates to reproductive harm, the safe harbor level for that has been identified as 0.5 micrograms per day. Micrograms is simply equals 1/1000th of a milligram, and it's a measurement of mass. So how much of this chemical is actually present in the product. So if you are able to identify that the chemical in question that's present in the product would only cause an exposure that's underneath the safe harbor level, then a warning is not required. However, if it's over the safe harbor level, then you don't get the benefit of the safe harbor and a warning is required. there's a question.
Okay, we have another question from the audience. If a chemical is on the list for inhalation hazards, but the list states that once the ingredient is in an emulsion, a warning is no longer needed, would you still recommend a warning?
I'm sorry, can you repeat the question?
Sure.
Do that one more time.
No worries. If a chemical is on the list for inhalation hazards, but the list states that once the ingredient is in an emulsion, a warning is no longer needed, would you still recommend a warning?
Okay, I think that the reason why I needed to repeat that is that the emulsion. I'm not entirely sure what you mean. I think what they mean is that the if it's based on an inhalation hazard, that the person has to inhale the chemical. If there's some kind of a safety to ensure that there's no way that a person can actually inhale the chemical, then there's no risk of exposure. And remember that Proposition 65 is based on exposures. So there's no risk that the person is going to actually be exposed to the chemical, then no warning would be required in that instance. So it's predicated on that if there's going to be exposure to a chemical to a consumer, then if there's a risk of cancer or reproductive harm that's been identified, a warning must be provided. But if there is no risk of an exposure, then there's no need for a warning hazard.
He's kind of qualified it. He said it is blended in a liquid emulsion and no longer airborne.
Mm-hmm. Well, in that case, no longer airborne. So if the chemical hazard is based on inhalation, there's no risk of exposure to inhalation because it's no longer airborne. Then in that case, I don't believe that a warning would be required. I think I would have to do a little bit more research just to confirm that. But based on the principles that I know about Proposition 65, in that instance, I don't believe that an exposure would be required because of the fact that there's no exposure risk. So I hope that answers the question that you had. All right, so Proposition 65, just going back to the regulation. So the warnings have to be clear and reasonable. And there is a safe harbor warning that's provided in the regulations that relate to Proposition 65 that's published by the OEHHA. They are responsible for creating a number of implementing regulations that will control what needs to be done to comply with the law. And there are a number of safe harbor warnings that are considered clear and reasonable by law. And the reason why those safe harbor warnings exist is to provide businesses with certainty that the warnings that they provide are clear and reasonable, and they don't have to worry about second guessing about what particular warning language and how it is the method that the warning is supplied is going to be clear and reasonable. So that's the benefit of the safe harbor, to give businesses certainty in how to provide a warning if and when they do need to provide a warning. And the method of transmission, there's a number of different ways that can happen. But there's one very, very common way, and the most often the way that you see it is in product labeling. So there's a product, there's the packaging on the product, and the packaging contains the Proposition 65 warning. A lot of times businesses really want to avoid having to provide a safe harbor warning, especially in the case for food, which commonly you might see that in dietary supplements. If there's a requirement for a Proposition 65 warning about a cancer risk or reproductive risk, oftentimes manufacturers and distributors, they want to avoid the necessity of providing a warning in that instance because for fear that it's going to deter a consumer from purchasing the product. Other methods can include posting notices. So that can be done through shelf labeling, that can be done through signs, it can be done through menus, it can be done through a combination. But that's another method for providing a Proposition 65 warning. And one of the key components that you have to provide the warning prior to the exposure. So the consumer has to be informed about the presence of the chemical and the fact that there's a risk of cancer and reproductive harm. And they have to have that information prior to making the purchase so they can make an informed decision whether they want to accept that risk or not. And the regulations, I'll just add, there is a third method that is in the regulation that provides that you can implement a system of signage, public advertising, an identifying system for a toll-free information service, whether by telephone or any other kind of system. The problem with that method is that it's not a pure safe harbor. And so you don't, because then it becomes a question about the reasonableness of how effective that advertising is in informing consumers about the risk of the presence of the chemical and the risk of cancer or reproductive harm. So then there is an assessment about how reasonable and clear that method of transmission is. So it's not a true safe harbor, even though it is an available method, but it's not a safe harbor method. The only real safe harbor methods are really putting the warning on a product label or through signage on a menu or shelf labeling. That's the most clear way to warn consumers, and that's the safe harbor. Anything that kind of deviates from that, and there's going to be a question about how reasonable that method was that was employed to communicate the warning to the consumer prior to the purchase. Anytime that there's going to be a question on that, then it's not a true safe harbor. The safe harbor is really meant to provide certainty. Yes, there is another question.
Another question. If, say, lead is sealed permanently and hermetically, or completely sealed against the escape of entry of air, with no chance of oral consumption, will a warning be required?
That is a great question. And a lot of times what plaintiffs will do is they'll simply test. Lead is a very, very common Proposition 65 chemical that's identified in what's called a 60-day notice of a violation, because A, is relatively inexpensive to the test for, and B, it can be a common ingredient, and but in terms of the question, if the chemical is hermetically sealed and there's no risk of exposure, again, I believe that in that instance a warning is not required because of the fact that there's no exposure risk to the consumer. But one of the risks is that a plaintiff may break down the product, find that there is a presence of lead, and notice up the 60-day notice, and so then it's a question of, well, what's the cost? Is it going to be, how do I prove that the fact that there is no risk of exposure when the plaintiff, all they really need to do to issue a Proposition 65 warning is that a chemical was present and that no warning was provided. That's the only thing that the plaintiff needs to do in order to initiate a lawsuit. And the only way to really protect yourself is to provide a Proposition 65 warning, because if there is a warning, then the plaintiff can't initiate a lawsuit. They can only do that if there's no warning and there's the presence of a chemical. So it's really a kind of a risk analysis about what is the likelihood that a potential Proposition 65 plaintiff is going to break down your product, find the chemical is present, and that no warning was provided, initiate a lawsuit, and then expend the money to defend the lawsuit to show that there is absolutely no risk of exposure because it's hermetically sealed. So that's really kind of, it becomes not such a clear-cut answer in terms of what the best practice is and what should be done in that circumstance. And I think that it really becomes a circumstantial kind of analysis about what is the level of risk versus the reason why you would think that I really don't want to provide a warning, and if somebody sues, am I willing to defend or not? In terms of who must provide the warning has to be provided by any person who manufactures, produces, assembles, processes, handles, distributes, stores, sells, or otherwise transfers. So it really kind of goes from the whole entire gamut of the supply chain. So we're looking at anybody who's manufacturers, distributors, and retailers. So they're primarily the business entities that are responsible for the warning. There's a lot of things that can kind of complicate this. You may have a manufacturer that is relying on suppliers to give them ingredients, and they need to know what's in the ingredients and to become aware of what chemicals might be inside the materials that are going into the product that are being manufactured. The distributors, they are relying on the manufacturer to provide them with the chemicals that are present in the products in order to, so that and then the retailers are also relying on the distributor or the manufacturer to ensure that the product is not going to require a Proposition 65 warning. So there's a number of different ways that a chemical might be present in a product where somebody along the supply chain may not be aware of it. So there's a number of risks with that, because if a distributor sells or if a distributor supplies products into California that are going to be sold by retailers, and that product contains a listed chemical and a warning should have been provided, the distributor may not have known that the chemical was present, but they're the ones that are faced with a Proposition 65 lawsuit, because typically the plaintiff will know about the distributor. They may ask the distributor to identify who the manufacturers are in the supply chain, so that way they can issue a 60-day notice to the manufacturer as well. But distributors want to ensure that they are getting clear certification or a protection from the manufacturer in the case that they are selling a product that would require a warning in California in order to protect themselves, whether through contractual indemnity, warranties. Those are probably the most common ones that you would look to. Yes, there is a question.
Okay. Recent notices are moving towards risks from dermal exposure as someone handles a product, example given, service part, as opposed to ingestion. Plaintiffs are using suspect methods of testing that are not reasonable expectations of use. Seen anything on these types?
I've not seen anything on those types. I mean, I can say that the plaintiff, when they issue a 60-day notice, they must have a reasonable basis to file a 60-day notice. And one of the things that happens with the 60-day notice is that they have to file a certificate of merit to the Attorney General. And that certificate of merit is not public; it's confidential. So the defendant does not get the benefit of seeing the certificate of merit. But the certificate of merit is meant to go to the Attorney General, so that way they can see that there is a good faith basis for the Proposition 65 notice. So the plaintiffs have to have something to go on, and that typically is some kind of a test that will identify that this chemical was present in the product. I think the questionable part comes in as far as how much of that chemical is actually present. So, for example, lead. Perhaps they found out that lead was present inside the chemical or inside the product, but it was such a small amount and it may have been below the safe harbor level. But they issue a 60-day notice anyway, because now because they know that it's up to the defendant to prove that the chemical in question was below the safe harbor and that they get the benefit of the safe harbor. So they know that going in, and that gives them some kind of leverage to hope to get a settlement out of it. So I can't answer that particular question, but that typically is what will happen. And if the plaintiff files a 60-day notice and issues a certificate of merit, there is no good faith basis for it, then it's a frivolous 60-day notice, and they can face repercussions because of that.
We've got another question, I think, relating to some of your answer on that one. Mm-hmm. In my understanding of Proposition 65, the burden of proof that exposure to a chemical falls below an established safe harbor level falls on the party introducing the material into the state of California. Mm-hmm. How does one go about proving that exposure to a chemical contained in a mixture might fall below the safe harbor value?
And that it's a wonderful question. In terms of the burdens at play in a Proposition 65 case, in order to get the benefit of the safe harbor, the defendant has the burden of proof. So it's a defense. They are the defendant is in a position of having to prove that the chemical in question was below the safe harbor level, and that's a complete defense, because if it's below the safe harbor level, then no warning is necessary. However, that's the defendant's burden. So in order to be able to prove that out, that would necessarily require an expert. It would require an expert that has familiarity with the chemical, familiarity with exposure levels, how the chemical is going to be exposed, and what kind of a risk of cancer or risk of reproductive harm that might pose, and showing and establishing through expert testimony, expert report, expert evidence that the chemical in question is below the safe harbor. That's really what it would take, because a lay witness is not going to be able to identify that, because they don't have the scientific training, background, education in order to establish that. So once you start entering expert into the picture, that's going to be expensive. It drives up the cost of the case pretty significantly. And when you look at a lot of these settlements, unfortunately, a lot of the settlements are really, really low. I should say fortunately, but the fact is that you may have a settlement that's going to be $17,000 or $25,000 or $50,000. When you start thinking about entering an expert into the picture, then that becomes an assessment about the cost of the litigation versus the settlement. However, if you decide to go that route in a test case, then that could be the benchmark to say at this level of a chemical in the product is below the safe harbor. So if I get issued a 65 notice again, I've got all of the expert materials in the bag already, and that can be used in order to ward off other Proposition 65 suits. But at the end of the day, it's the defendant's burden. The defendant is going to have to pay for the expert. The defendant is going to have to put the expert on to establish at the safe harbor level that the defendant gets the benefit of the safe harbor level. In terms of the providing the warning, the one thing I'll add is that the statute mandates that to the extent practicable, the regulatory authorities, being the OEHHA, when they issue implementing regulations, they are going to try to put the obligation on the manufacturer or the distributor to provide the warning. So they want to lessen the burden on retailers to provide that warning. The regulations are designed in a way to try to put more of the burden on the manufacturer and distributor, because of the fact that they are the ones that are primarily responsible for the materials and the chemicals that are going into the product. So they want to place the responsibility of providing that Proposition 65 warning as much as they can through the regulatory scheme that's developed on the manufacturers and distributors, and not on the retailer.
Another question. Is there a downside legally with over-labeling? An example, putting warnings on items that might actually not contain toxic exposure levels of Prop 65 listed chemicals?
That's a wonderful question, and there is a real problem with over-warning for Proposition 65. In California, Proposition 65 warnings are somewhat ubiquitous. Even Disneyland has a Proposition 65 warning for environmental risk, for cancer or reproductive harm. And so people going to Disneyland are not usually thinking that they're going to be exposed to cancer-causing or reproductive-causing chemicals. So there's a really large problem with over-warning, and in the case that a warning might appear on a product that doesn't necessarily have a chemical, and no warning is really required. So that has really encouraged people to be more defensive, because in order to really safely protect yourself from the risk of any kind of Proposition 65, lawsuit is to provide a warning, even when no warning is required. The Office of the Attorney General has I've looked at their website on this question, and they strongly discourage people from providing a Proposition 65 warning when none is required. But I haven't seen anything in there that would preclude you from providing a Proposition 65 warning even when you might not need one. For example, if you believe that you have the benefit of safe harbor, but you provide the Proposition 65 warning anyway, in order to ward off any kind of risk of being faced with a 60-day notice. The flip side of that coin is you may decide that you're going to provide a Proposition 65 warning when you know that there's no chemical in there that requires one, just to be defensive. Well, you have to weigh that against the fact that your product might be on a store shelf. It includes a Proposition 65 warning, but another product that's a competitor that might have relatively the same ingredients, they don't have a Proposition 65 warning. So the consumer may decide that they're going to use their choice to purchase the product without the warning versus one with the warning. So that's an individual assessment of what kind of risk you're willing to take on. But at the end of the day, if you know the chemicals that are in your product and you know the chemical is not something that's on the list, then no, you don't need to provide a warning, even though you might just think that why not just provide a warning anyway? You don't need one. So you're not going to, any plaintiff attorney that files a 60-day notice, they have to identify the chemical that's present in the product. That's one of the things that's required for the 60-day notice, that they identify not just what the product is, but they identify the chemical in question that's present in it. So if your product does not contain that chemical, the plaintiff is not going to have a basis to identify anything as a violation. So on this slide, it's just it's a sample of what the warning is for the safe harbor. Cancer, it just simply says, warning, this product contained a chemical known to the state of California to cause cancer. Reproductive toxicity, the warning is, warning, this product contained a chemical known to the state of California to cause birth defects or other reproductive harm. And then the next slide is a combination of both. So there are certain chemicals that pose a risk of both cancer and reproductive toxicity. So the warning simply lays out that it's, the chemical is known to the state of California to cause cancer or birth defects or other reproductive harm. So this language that you see here is the safe harbor. If you have this warning label on it, then there's absolutely no question that the warning is clear and reasonable. So this warning is provided on product labeling, it's provided on retail shelf labels, whatever kind of method that's provided. This is de facto, it's per se reasonable. And that's why you get the benefit of the safe harbor. So if you start introducing or deviating away from the language, then it's not a safe harbor. It's not a true safe harbor. Some labels that I have seen will include the chemical that's actually there, the name of the chemicals. I don't see that very often, but from time to time I've seen examples of a warning that includes the chemical. It's not a true safe harbor warning, but it's pretty hard to believe that that would be not clear and reasonable, because it provided even more information than the normal warning. But in terms of when you're trying to decide on what does the warning language need to be, you have a clear safe harbor that you can look to. In terms of penalties, and what would happen if you faced a 60-day notice, similar penalties range up to $2,500 per day for each violation. Exactly how that's determined, it's hard to say. Whether it's, what is the violation? Is it simply selling the product? Is it for each product that's sold on a particular day? That is not particularly clear. But either case, civil penalties can only be up to $6,500 per day. That's based on a number of different factors that a court is supposed to consider. They're supposed to consider nature and extent of the violation, the numbers of and severity of the violations, the economic effect of the penalty on the violator, whether the violator took good faith measures to comply with the chapter, willfulness of the misconduct, the deterrent effect of the penalty, and any other kind of factors that justice may require. And that's just the catch-all. The other penalty that is available is injunctive relief. So typically a Proposition 65 lawsuit will involve a request for civil penalties, and it will be a request for injunctive relief to stop the defendant, the retailer, distributor, from continuing to sell the product into California. The other very, very important piece of the penalty is the attorney's fees and costs. Plaintiff's attorneys, when they, in addition to the civil penalty, they can obtain attorney's fees and costs. They don't actually, the plaintiff's attorney does not actually get to keep the civil penalties. The civil penalties go to a fund that is set up to help implement the Proposition 65 and the regulations, paying for the experts to identify chemicals. So all of that goes into a fund. But the plaintiff's attorneys get to walk away with the attorney's fees and costs. And another thing I would just add about the factors for the civil penalty, in terms of settlements, all the settlements for any kind of Proposition 65 lawsuit must be approved by a court, and all settlements are public, which is pretty important. The penalties that are going to be assessed as part of the settlement have to be reasonable in light of these different factors that a court is going to consider. So the settlement amount is too high in terms of it's going to have a really large adverse effect on the violator. So there's the civil penalty that's actually imposed has to be congruent with the factors that are identified here for the court. So in terms of who can file a complaint, the Attorney General, district attorneys, or in some cases city prosecutors can file a Proposition 65 lawsuit. City prosecutor, that's limited to city prosecutors for cities in populations of 750,000 people or more. The most common way that Proposition 65 cases are brought is citizens in the public interest. So because citizen suits, they're entitled to receive attorney's fees and costs, and they're most commonly the ones that are bringing the Proposition 65 claims. It's not very often that an attorney general or a district attorney or a city prosecutor is going to file a Proposition 65 lawsuit. Generally, the range for the attorney's fees to the civil penalties that are instituted is about 75 to 25. 75% attorney's fees, 25% civil penalties. A lot of this stuff is available on the Office of Attorney General's website on their information page for Proposition 65. Like I said before, they publish a summary of all the settlements that occurred in the prior year, so you can look at all of the different consumer groups and plaintiffs that have brought a Proposition 65 claim, the defendants that were identified in the lawsuit, an idea of what the settlements that they were getting from whatever defendant there was. So the way that typically will roll out in the case of a citizen suit, a plaintiff's attorney identifies that there's a chemical in your product and that no warning was provided. They'll issue a 60-day notice. And then they have to submit a certificate of merit to the Attorney General. All 60-day notices are public documents that are available on the Attorney General's website. The Attorney General will simply review it. They'll see if there's a good faith basis for the lawsuit, and they'll decide on their own whether they want to initiate a suit. If they do initiate the suit, then the civil plaintiff cannot file a lawsuit. Only the Attorney General can. Typically, what happens is the 60-day notice will expire, and on the 61st day, the plaintiff can choose to file a lawsuit then. There's a one-year statute of limitations on Proposition 65 claims. And there's no tolling provision for that 60-day notice. So if you file that 60-day notice, one of the ways that you can try to limit your liability exposure is to stop selling the product, stop the exposure from occurring. Because when the plaintiff files on day 61, they can only get civil penalties for any violation that occurred 1 year prior to the day that the lawsuit was filed, not the day of the 60-day notice. There's some debate about the limitations. That there's some claims attorneys that will argue that it's really a 4-year statute of limitations, and they argue that based on what's called the UCL, that's the unfair competition law in California. However, I'm aware of at least one unpublished case that has said that no, that the statute of limitations is 1 year. It can't be based on the 4-year statute of limitations. And the argument goes is that the UCL claim can be based on a violation of another statute. In this case, it would be a violation of Proposition 65. And they'll want to get the benefit of the 4-year statute of limitations, and in addition to the penalties that are assessed under Proposition 65. There's at least one case that has rejected that argument. And they said that if it's a claim that's based on the UCL, the only relief that's available for a UCL claim is injunctive relief, not civil penalties. So after the complaint of violation, either the way that it typically rolls out is that there is a settlement and that there is a court approval of the settlement. The other avenue, of course, is the litigation of the merits of the Proposition 65 claim. In terms of notice, the plaintiff can file the complaint, as I said before, if a prosecutor initiates the suit. The notice has to include the party's name, the defendant's name, the list of chemical identified, so that way you can find out whether the chemical is on the list, if there's a safe harbor, and do your own investigation to see how the chemical may have ended up in the product. It must be identified the route and type of exposure. Is it an inhalation exposure? Is it an oral exposure through consumption? Or is it exposure through contact? So they have to identify the type of exposure that there is. So in the case earlier about lead being hermetically sealed inside the product, well, the plaintiff in that case would have to identify the route of exposure. But if the lead is hermetically sealed and the consumer can't come into contact with it, that 60-day notice period had to give some kind of a basis of how the consumer was exposed. And the 60-day notice also has to identify the product so you can figure out exactly which product it is that is alleged to include the chemical in question. And the certificate of merit has to be sent to the Attorney General. The defendant, in this case, does not get the certificate of merit. That's only sent to the Attorney General, and that is confidential. However, all the 60-day notices are public, and those are posted on the Office of Attorney General's website. So the plaintiff's burden of proof, they have to essentially prove that the product contained a listed chemical and the product did not contain a warning. They don't bear the burden of proof regarding the safe harbor levels. The chemical did not pose a risk of cancer or reproductive harm. So that really puts the onus on the defendants. Another element of proof that's not listed here is the intent and knowledge factor. So that's really going to become a question of the plaintiff will try to establish the intent and knowledge by the fact that the chemical or the product was sold in California. The defendant introduced the product into California for sale, and that they knew that the chemical was present in the product. If there's a potential defense that I see there for a defendant in the case that they had no knowledge that the chemical was actually present, but then that becomes an issue that has to be litigated and proven. For the defendant's burden of proof, they have to prove that the warning was reasonable. If they do not rely on a safe harbor warning, they have to prove that the exposure was below a safe harbor level if a safe harbor level is available. And remember, there's only 300 different chemicals that have a safe harbor level, and there's 900 chemicals on the list. So for 600 of those chemicals, there's no safe harbor level that you can rely on. There's a number of defenses that are available. There's a naturally occurring elements exception, there's a cooking exemption, and those are regulatory exceptions primarily for food. Statute of limitations. So if the plaintiff is looking for a violation beyond 1 year from when the complaint was filed, you get the benefit of the statute of limitations that no, you can't assess any kind of civil penalties for a violation that occurred 1 year prior to the initiation of the lawsuit. There is an exception for federal preemption. So we got about 5 minutes left. So I'm going to try to wrap up as quickly as I can. But federal preemption, one example is that there, for meat labeling, there's a federal meat labeling regulation as far as what kind of warning is provided on meat. That regulation preempts Proposition 65. Then another defense is the 12-month grace period for newly listed chemicals. The prior settlements, I just want to touch on this a little bit. All the settlements that are approved by courts are public. So that can become a very, very important resource. It can be an important resource for if you receive a 60-day notice from someone, you can immediately start to research how many lawsuits that plaintiff has filed before, because usually they are very familiar and they've done this a lot before. You can take a look at the average range of settlements that this particular plaintiff has gotten. You can look at the settlements to themselves to find out what kind of provisions are in the settlements that are typically obtained. Are there methods of testing, or what kind of methods of reformulation for the products in question? Is there what kind of warning provisions that are in that settlement? The other pieces of it would be monitoring. What kind of testing has to be done after the settlement to ensure that the defendant is in compliance with the method of reformulation that is adopted. And reformulation may be simply ensuring that the chemical in question is below a safe harbor level. They only contain, for example, lead. It only contains 0.4 micrograms per serving for maybe food, as an example. Or it might be, require reformulating to eliminate it completely. But all the settlements are a rich resource to find out what kind of terms that this particular plaintiff has gotten, and it's also a way to, as a preventative tool, so you can see, well, there's this chemical, but I need to have some kind of method to ensure that I'm below the safe harbor. You can look at the settlements to see if there's anything out there that relates to the chemical in question, and see if there's any kind of reformulation methodology to ensure that you're below the safe harbor. In terms of just to touch briefly on insurance, there are some insurance policies out there for Proposition 65. I'm not familiar with very many. One of the most recent ones that I saw, I believe that came out in the past year or 2 years, is Wells Fargo. Wells Fargo has insurance for 6 different lists of chemicals for plasticizers. So it's a very, very narrow range of chemicals in comparison to the 900 chemical list. But if you have a product and you're worried that that there might be this chemical, this plasticizer that will be present in your product, you can try to get some insurance. There are some policies covering false advertising or failure to warn. This is a failure to warn regulation, Proposition 65. So there may be some argument that you can try to use if you have a policy that covers false advertising or failure to warn claims. That might be enough to trigger coverage. There's I've seen some arguments out there, conversation about coverage under a commercial general liability policy. However, those policies will be predicated on bodily harm or property damage. There's a California case that I've cited here that you can take a look at. Essentially, the plaintiff argued that Travelers Insurance should have had a duty to defend against the Proposition 65 claim, and they tried to argue that under the bodily harm and property damage coverage provision. The court rejected that because Proposition 65 is remedial. It's punitive in the nature of a penalty. It's not meant to reimburse a plaintiff for harm, for bodily harm or property damage. That's not what Proposition 65 is there for. So therefore, there was no coverage. The other thing I want to touch on is that there are proposed regulations now by the OEHHA. They published a draft in March of 2014. It's still in the public comment period, and so it's been going on for about 2 years now. But based on the activity from the OEHHA, I'm guessing, but I think that the regulations will be in place by late 2016, early 2017. There is a 2-year compliance period for the new regulations when they actually do come into place. So it's not going to come into effect right away. There's going to be a 2-year lag before manufacturers, distributors, retailers have to start complying with the new regulations when they are finally implemented. And there's quite a few changes to the warning labels. There's going to be there's more regulation about text size. There's regulation for having chemicals actually be identified in the warning. That there are labels. You see this little yellow triangle that has to precede the warning. For internet purchases, there's regulation will cover internet purchases and provide that a warning needs to be provided at the time of the internet purchase. Catalogs, there's more tighter regulations about associating the Proposition 65 warning with the product that's being purchased in the catalog. And there's some regulation for food products. For food products, the warning actually has to be set off in a box, and it has to set out what the chemical in question is. And there's also a link to a website that has to be provided. That there's this yellow triangle, and it also has regulations about internet purchases and catalogs similar to product labeling. So just as an example for an on-product label, here's a few examples of what the safe harbor would look like for the new warning regulation. So you can see the yellow triangle. The warning has to be in capital, bold-faced font, and it has to include the website. And then this warning label right here is a sample for the food product warning. So you can see that it's set out in the box, not necessarily in that color. But you can see that there's a lot more detail about the name of the chemicals that are prompting the Proposition 65 warning. So just to conclude, I know I rushed a little bit towards the end, but if anybody has any questions, I'm open to answering any questions. We're all good? Okay, we don't have any questions at this time, but so I just want to thank everyone for joining today. There's been a lot of interest about Proposition 65. So if there's any questions that you might have for a follow-up, feel free to contact me either through email or telephone, and I'll be happy to try to answer any follow-up questions. Thank you very much.